Judgment in the appeal. The Queen on the application of Hemming and Westminster City Council.
This judgment follows on from previous judgments of the Supreme Court dated 29th April 2015 and of the European Court of Justice dated 16th November 2016. The respondents are sex shop operators in the Westminster City area. The appellants are Westminster City Council, who run a sex shop licensing scheme. This costs money to cover the costs of processing licenses and, more significantly, the costs of enforcing the scheme against unlicensed operators. The essential issue is whether Westminster City Council can recover not merely the costs of processing licenses, but also the costs of enforcing the scheme in circumstances where they had in fact charged both sets of costs up front when applications for licenses were made, on the basis that the enforcement costs element would be repaid if no license was forthcoming. The relevant years are those ending 31st January 2011, 2012 and 2013. The courts below held that Westminster City Council was not entitled to recover enforcement costs at all. They also held that Westminster City Council had not, in fact, determined any fees by a proper procedure for the first 2 years, although they had done so for the third year. So, the Court of Appeal ordered Westminster City Council to determine a fee excluding enforcement costs for the first 2 years afresh, and to repay the excess enforcement fees charged in respect of all 3 years. Before the Supreme Court, concluded in its first judgment that it was, contrary to the view of the courts below, legitimate to charge enforcement costs when a license was granted rather than up front. But we were uncertain whether under European Union law, the Provision of Services Regulation 2009 being the domestic emanation, Westminster City Council was entitled to charge enforcement costs up front with applications. On a reference, the European Court of Justice held in its judgment not. The question now is whether, since Westminster City Council in fact charged the enforcement fees prematurely up front, it can recover them for the respondents. They total some £1,189,000, together with a further sum of £227,779 said to have been overpaid by Westminster City Council under the Court of Appeal order. In a unanimous judgment given by Lord Mance, the Supreme Court now holds that insofar as the Council has determined a reasonable fee, including enforcement costs, it is entitled to be paid or repaid it now by the licence holders according to the pro rata sums which they actually received from Westminster City Council. The issue of the reasonableness of the sum identified as enforcement costs by Westminster City Council is to be remitted as agreed to the Administrative Court, together with the claim to recover the £227,000 odd pounds allegedly paid by mistake. The reasons for this conclusion are that although reference was made on each side to principles of unjust enrichment, the correct analysis is a simpler one. The Council's scheme was only defective insofar as it required payment up front at the time of the application. EU law permits a fee covering enforcement costs becoming due upon the grant of a licence. The licences did become due, so the fee became due in respect of each of the current licence holders. As a matter of both EU law and domestic law, there is no imperative to treat the whole scheme as invalid rather than to invalidate it to the extent of the inconsistency. As a result, in relation to the 3 years before the Supreme Court, taking the third, ended 31st January 2013, in the light of the Supreme Court's judgment, the Council is now entitled to recover the enforcement costs which it repaid, subject to a determination as to what were reasonable enforcement costs. As regards the first 2 years, The Council, as mentioned, failed to determine any annual fees by a proper procedure for those years. Pursuant to the order of the lower courts, they did so retrospectively in respect of those 2 years on the basis that enforcement costs should be excluded. The lower courts were incorrect in excluding enforcement costs. The Council could and should have been ordered to determine a fee for those 2 years, which included enforcement costs, and the Council must now be put in the same position as it would have been had the Court of Appeal reached the same conclusion as the Supreme Court now has. The admissibility and merits of certain lesser issues, including by agreement the alleged overpayment, can, in the Supreme Court's view, appropriately be remitted to the Administrative Court. The Court will adjourn.